Good afternoon from Beirut, everyone, and welcome to this magnificent online public gathering. My name is Jelena Plamenac, and I'm Diakonia's manager of Lebanon Resource Desk for International Humanitarian Law. I'm delighted that we are together today in the same virtual space and that I see among us so many dear colleagues, friends and fellow humanitarians from leading international and civil society organizations. I see representatives of governments, professionals, professors, and students from the entire Arab world. Today we are going to delve into a subject that is very close to my heart and that concerns us all, and that is giving relief to a person in need, to stay in life and dignity. We will talk about an unusual aspect of that giving, when the relief needs to pass across a state border into the situation of an armed conflict. It is a simple and yet highly complex life situation. Imagine me, hungry, thirsty, wounded, and in need of a roof above my head. You have food, drinking water, medicine, and a shelter that you want to give to help me to survive harsh life conditions. It is a simple human impulse of compassion to help the other. But what if you see me like that, while standing across a state border, and for your aid to reach me safely and legally, it needs to comply with certain legal rules along the journey and to pass through security and other operational obstacles on the way. Will your assistance reach me on time or at all? In this scenario, I'm one of 11 million Syrian civilians who need to access essential humanitarian items every day to stay in life for the 10th year of the armed conflict in Syria. This panel talk will, for the first time in public, critically explore what are the key legal and operational aspects of cross-border humanitarian operations into Syria, with the focus on bringing more clarity on legal dimensions that regulate this situation on the ground. We will also discover operational challenges that thousands of humanitarian aid workers and international lawyers face while following that human impulse of helping the other. Together with me today are four powerful humanitarians who have devoted many years of their professional lives to create better legal and operational conditions for cross-border relief to reach civilians caught in conflict-affected areas across Syria. Professor Michael Bothe is Professor Emeritus of Public Law at the Goethe University in Frankfurt. He held chair in public international law at the universities of Hanover and Frankfurt and served as a visiting professor in many universities around the world. He presided leading international law bodies, including the International Humanitarian Fact-Finding Commission, and served as a counsel before International Court of Justice and German Federal Constitutional Court. Professor Bothe also served as a delegate and advisor in a number of international conferences, of which one particularly stands out for our discussion today. Professor Bothe was responsible for negotiating the relief provisions of the 2 additional protocols to Geneva Conventions at the Diplomatic Conference in Geneva in 1974, and he acted as a spokesperson for Western European and Others group in the negotiations on the final shape of Additional Protocol 2 of 1977. He's the author and co-author of many books and articles on questions of international law, including the famous commentary to the additional protocols to the Geneva Conventions. Good afternoon, Professor, and welcome to the panel talk. Emanuela-Chiara Gillard is the Senior Research Fellow at the Oxford Institute for Ethics, Law and Armed Conflict, and the Research Fellow in the Individualization of War project at the European University Institute. From 2007 to 2012, Emanuela was the Chief of the Protection of Civilians section in the Policy Branch of the United Nations Office for Coordination of Humanitarian Affairs. Before that, for 7 years, Emanuela was a legal advisor at the International Committee of the Red Cross, responsible for providing legal advice on the protection of civilians in armed conflict. Emanuela is co-author of the leading legal doctrinal resource on the humanitarian relief operations in armed conflict, the renowned Oxford Guidance on the Law Relating to Humanitarian Relief Operations in Situations of Armed Conflict, published in 2016. Professor Bothe was also among the prominent experts who was consulted in the preparations of this guidance. Hi, Emanuela. It is really fantastic that you are with us today. Misty Buswell is the Regional Director for Policy, Advocacy and Communications at the International Rescue Committee, based in Amman, Jordan. She has worked on humanitarian policy issues for 15 years in Geneva and New York, and has spent the last 7 years in the Middle East, working on Syria and other regional crises. She was involved in advocacy efforts for the adoption of the initial cross-border resolution of the United Nations Security Council in 2014, and has been actively engaged in the recent efforts to secure the continuation of the cross-border mandate in Syria. Hi, Misty, welcome to the panel. Rachel Sider is the Syria Policy and Advocacy Advisor at the Norwegian Refugee Council, where she focuses on principled humanitarian assistance, access, and internal displacement. She has spent the past 6 years working with communities affected by conflict in the Middle East, including in Iraq and Gaza. Professor Botem, Emanuela, Misty, and Rachel, thank you so much for agreeing to be with us today and to share your knowledge, historical insights, and professional experience in striving to really improve and advance the humanitarian assistance into Syria. So let us kick off this discussion with explaining the roots of the entire matter. Misty, International Rescue Committee has been operational from the very beginning of the armed conflict in Syria. Why NGOs started to deliver cross-border operations back in 2012? What was the relevance of this humanitarian work?
Thanks, Yelena, and thanks for the opportunity to be a part of this discussion today. And as you said, in 2012, a number of NGOs had started operating across borders into Syria. And this was largely based on the fact that, we had really been witnessing a humanitarian catastrophe unfolding. And it was a really horrible situation. By 2012, we had 1.5 million Syrians who had already fled the country and become refugees. There was also large-scale internal displacement happening, and there were 4 million people who were already in need of humanitarian aid just by 2012. So, there were not very many NGOs who had been working in Syria prior to the conflict, either international or national NGOs. And so with the suffering that was going on at such a massive level, we were looking for ways that we could provide aid. I was with another large INGO at that time, and we, along with other organizations, were looking how we could aid. And so the initial thinking was that we would obtain agreement from the government authorities and scale up operations from Damascus. But it really quickly became clear that this was not going to be possible, and that there were civilians who were in dire need of aid that could be reached more directly and effectively through cross-border assistance. So with the humanitarian imperative top of mind, many of these NGOs began setting up cross-border operations. And you know, I think in the beginning it was a very new situation for NGOs to be working in this way, and we were all, you know, really trying to do what we could to bring this much needed aid. You know, coordination efforts were certainly not what they are now, or what we would normally see in a humanitarian response, where we would have, you know, the UN coming in and providing the humanitarian architecture, and having that real UN support for resources and funding and that sort of thing. So that was, you know, the situation we were in, NGOs on a fairly ad hoc basis, but, you know, really in a situation where we were able to provide aid, but it was not, you know, the coordinated response that we see now. Information management was a challenge, and there was a reluctance to share information. There were not common needs assessments. You know, essentially we had a response that was happening from Damascus, and we had a cross-border response, and they were functioning as independent responses. And so it really took, you know, you know, cross-border resolution to make that change. But in the beginning, you know, the very first humanitarian appeal, NGOs and cross-border who were working cross-border couldn't participate. So the very first humanitarian appeal for Syria in 2013 didn't have cross-border work in it. And there just wasn't an accurate picture or understanding of the totality and the scale of the needs across the response in the whole country. And you know, I came across a quote from a senior UN official at the time that I really think sums up the rationale for why cross-border operations have been so necessary. And he said back in 2013, you can't negotiate the 54 checkpoints between Damascus and Aleppo every day with a quantity of aid that Aleppo needs, but you can drive it in 1 hour from Turkey efficiently and effectively. There's no logical reason why you can cross a conflict line but not a border, but there is a consequence. People are dying. And so for us, that was the motivating factor, and that was the rationale.
Thank you. And it is a very charged, uncertain, and confusing situation where the humanitarian operations are just starting in an armed conflict that kicked off, and we still don't know what is actually going on the ground. But there is a legal framework within which all those
humanitarian relief operations in situations of armed conflict. And the key elements are straightforward and for the most part the same in both international armed conflicts and non-international armed conflicts, such as the one in Syria. Primary responsibility for meeting the needs of civilians lies with the party to the conflict in whose effective control they find themselves, be that the state or the organized armed groups. If this party is unable or unwilling to meet these needs, offers may be made to carry out relief operations that are humanitarian and impartial in character. The consent of the affected states is required. There are two circumstances in which states have no leeway to withhold consent. The first is situations of occupation, if an occupying power is not in a position to ensure the adequate provision of supplies essential to the survival of the civilians, it must accept offers to conduct relief operations. And secondly, situations where the United Nations Security Council has adopted binding measures requiring parties to consent, or more radically imposed relief operations on the parties. turning our attention to later. In all other situations, so apart from situations of consent, of occupation, or where the Security Council has acted, consent is required, but may not be arbitrarily withheld. And then finally, once consent has been obtained, all parties to an armed conflict must allow and facilitate the rapid and unimpeded passage of supplies, equipment, and personnel, but may impose measures of control or technical arrangements for such passage. They could include searches, particular routes or times that must be taken, or in COVID days, measures, other precautions to prevent the spread of the virus. Rules foresee two successive steps. So the initial authorization to be in the country and to carry out the relief operations, as Misty noted earlier, there simply weren't that many, if any, humanitarian actors in Syria when the violence erupted. It was more of a development context. So that's why the question of initial consent assumed so much prominence in relation to Syria. That's the first step, authorization, fortunately. But Yelena, are you with us?
Yes, apologies, but here
not really.
In our office, we are having electricity cuts, so my connection is getting down in the middle of the discussion. Apologies for that. I'm going to do my best to stabilize it through some options. Thank you, Emanuela, for the overview. And now if we zoom into the situation in Syria, where we are today with cross-border operations. The specific issue is that we have the relief coming from neighboring country into the territory outside of the control of the government without passing through the territory under the control of that territorial state. So the question, Professor Bothe, for you is the consent of that territorial state required in this factual scenario?
My clear answer to that is no. And I'll explain. The two protocols use the word party concerned. Now, what makes the concern? For Protocol 1, it is obvious, and there was no disagreement whatsoever on that interpretation, that concern meant that the operation, the relief operation, takes place or has to pass through territory controlled by a party to the conflict. And these parties where the relief operations had to go through or happens were concerned, and their agreement is necessary. Now, the debate is triggered by the fact that Protocol 2 uses the singular, the high contracting party concerned. So has concerned a different meaning in Protocol 1 and Protocol 2. I think an obvious answer to that is no. Any systematic interpretation of what is said by Protocol 2 leads to the result that concerned means the party which is in control of the relevant territory. And the singular is explained by the drafting policy of Protocol 2, which took place at the end of the conference, of the diplomatic conference in '77, namely that there was no more any mention of the non-state party except in Article 1 of the protocol. And that explains the singular, nothing more and nothing less. And that means in the situation which you describe is no agreement by the Syrian government is necessary as a matter of law. What is necessary as a matter of fact is the agreement of those powers, authorities, however you call them, who are in control of the relevant territory. So that would be my definite answer.
Thank you. And I know, Emanuela, you have a different view. So it's really good that we have both positions on the same subject.
Thank you very much. And this has been one of the most complex legal questions relating, that at least Syria has brought up, and experts have disagreed over the years. So I think there's two provisions that we need to look at. The first is, in fact, Common Article 3.2, which provides that impartial humanitarian bodies may offer its services to the parties to the conflict. It's a provision that applies in non-international armed conflict, so the reference to parties to the conflict relates clearly to both states and organized armed groups. The problem, or the issue, is that we cannot look at the rules of IHL in isolation. We need to put them into the context of public international law more generally, and in particular the rules of public international law regulating sovereignty and territorial integrity. And conducting operations in the territory of a state without its consent would be a significant infringement of its territorial integrity. Which means that the more traditionalists among us regretfully feel that they need to look for something more affirmative than what we currently see in Common Article 3, which is definitely the possibility of making offers, and that's important because it indicates, for example, that it's not in any way unlawful, illegal to engage with parties to offer services, but they're completely silent on the question of whose consent is required, who must agree to those offers. So there was a reluctance among legal experts to say, on the basis of that silence, we think that it is enough for the party to whom we make the offer to consent. Moreover, Common Article 3 would only cover certain humanitarian actors. It would cover humanitarian actors, but not, for example, any state that would want to carry out relief operations. Provision is the one that Michael presented to us, Article 18.2 of Additional Protocol 2, which is more explicit and refers to the need for the consent of the high contracting party concerned. And as Michael accurately summed up, the discussion here goes to whether a party is, in what circumstances a party is to be considered concerned. Michael says it is only if it is in control of the territory through which the operations must transit or where they're carried out. Others, again, adopt a more conservative position and say, no, it is concerned if it is within its territory, regardless of whether or not it is in control of it. So these were the two opposing legal views. I think it's important to bear in mind 2 points. First, as Michael has said, this is the position as a matter of law. As a matter of operations, it is fundamental to have the green light of all parties that are in control of the territory through which you're transiting or operating. And then for our discussions, it's also important to bear in mind that as these conversations were taking place among experts in 2014, the Office of the Legal Advisor of the United Nations determined that as far as UN operations were concerned, the consent of the government of Syria was required. They didn't give a reason for this conclusion, but that was very much the position that UN agencies were up against in terms of their own operations before the adoption of this resolution.
Thank you. It's a very fascinating discussion and certainly not a clear legal cut. We are going to return back to the issue of consent in a bit.
Well, may I add?
Sure, Professor. Please.
Two or three sentences to that.
Yes, please.
His arguments quite often before just the argument of sovereignty. Sovereignty is law, and it's an obligation upon a state. That's it. And this is not a violation of international law. It's of sovereignty. It's obedience to international law. It's realizing, it's implementing what is a
capital, as well as the cross-line operations that were also attempted both prior to and subsequently to the adoption of the resolution. So perhaps for those of you who are a little bit less familiar with this side of the humanitarian response, we're talking about NGOs, both international and national alike, to serve areas that were under the control of organized armed groups from government-controlled Syria, and familiar with the various interagency convoys, which was one modality that was established in 2014 to organize the delivery of assistance cross-line. But there were also attempts by NGOs starting in 2013, if not earlier, to reach people who were in areas that were labeled besieged and hard to reach by the United Nations. In 2016, this amounted to 4.5 million Syrians, and the number has evolved and shifted. But these convoys were organized through the United Nations with the support of the ICRC and SARC, and were highly controlled in their delivery, required monthly, if not bi-monthly, permissions, approval letters from various entities, including ministries and security actors, municipalities, individuals at the governorate level, and negotiations throughout that process to also ensure that while cross-border aid was being delivered into these areas, efforts were also attempted and hopefully successful in serving people from the Damascus hub. What we saw during that period was the regular removal of medical supplies from these convoys, the difficulties of negotiating through these cumbersome approvals processes that required tremendous amounts of resources in terms of time and personnel, but also the often unsatisfactory results of these approvals. So convoys would be permitted after months of requests, often for a limited scope of what was initially requested in the original approvals. And we've seen that really evolve over the course of the conflict. Some of you have probably followed that the number of convoys and the nature of cross-line aid delivery has also shifted as the conflict has evolved. We've really seen a tremendous reduction in the need to see the traditional cross-line interagency convoy take place. But of course, there are areas, including Rukban, that continue to be highly underserved and inaccessible to humanitarian actors, both from the cross-border side of things, as also seen from the government-controlled area perspective. The last convoy we saw to Rukban, for instance, took place in September of last year, and prior to that in February. So we've seen a real reduction in the prospects for securing both reliable, timely, and consistent access across conflict lines. Happy to touch on some more of the operational perspectives later from the Damascus and cross-border perspective. But Yelena, I just wanted to jump in with some of the perspectives from the other side of the response and complement some of what Misty had said earlier. Thanks.
Right, and thanks so much, Rachel, for explaining to us the difference between cross-border and cross-line operations, and also the importance of the areas under the government control and getting the humanitarian aid also within those territories. I would like us to now shift the discussion.
Obligations and a call for compliance. What is completely unusual is what happened in July 2014 with the unanimous adoption of security. Now, I don't know if you're with us, Yelena. We had a slide foreseen, but if you can put it up, great. If not, doesn't matter. What was extraordinary? It was in this binding the resolution, the Security Council did three things. First, and very significantly, it decided that United Nations humanitarian agencies and their implementing partners were authorized to use routes across conflict line, as well as the border crossings, 4 named border crossings, 2 on the border with Turkey in the north, Bab al-Salam and Bab al-Hawa, 1 coming in the east from Iraq, Yarubia, and 1 from Jordan, Al-Ramta, in addition to those already in use. So let's just pause here a second and look at exactly what the Security Council did here. Essentially, it sidestepped any rules of IHL that might require the consent of the parties. In a way, it put those to the side and said, it is not necessary to obtain the consent of the parties, of the government of Syria, for humanitarian operations across conflict lines, and also those coming in across these 4 named crossings, in addition to any crossings that were already in use in July of 2014. So quite unprecedented imposing of particular relief operations. What else did it do? The next slide, Jelena. In the next paragraph, if you recall, I said parties are entitled to impose measures of control on any relief consignment. And in a way, this is what the Security Council did. It recognized this entitlement and established a monitoring mechanism under the authority of the United Nations Secretary General to monitor the loading of all humanitarian relief consignments of the United Nations agencies and their implementing partners at those 4 named crossings. So this is the UN and NMM that many of you will be familiar with. And it's a recognition of the entitlement of parties to, among other things, check relief consignments to ensure they are exclusively humanitarian in nature. And then finally, 3rd slide, Jelena, please. Something that has received far less attention is this decision that all parties to the conflict shall enable immediate and unhindered delivery of humanitarian assistance throughout Syria. So this sounds more like the exhortations we are used to hearing the Security Council make, but it is a binding decision as well. So this is the unprecedented involvement of the Security Council in the relief operations in Syria.
Thank you, Emanuela. And now when we are zooming back to the ground and the reality, how did this resolution impacted humanitarian operations on the ground? What changed as of that moment? What stayed the same? Misty, could you maybe walk us through these changes and additions?
Sure, thanks. Well, I mean, as Emanuela has explained, you know, this was quite groundbreaking in some ways to see this resolution, and I think it took time, but eventually what the end result has been is that the effectiveness and scale of the response has massively improved and increased. You know, once that the UN felt that they had then, you know, we did see the strengthened coordination mechanisms. We had the whole of Syria architecture created, which, you know, it's quite an interesting architecture and probably one of a kind, but really did support strengthened information sharing, humanitarian needs overview, more consistent indicators for measuring needs and response, and you know, it covered the entire country. And for the first time, the humanitarian appeal looked at the totality of needs and the amount of money that the response was costing, as well as what was being delivered on the ground. NGOs also were in a position to receive funding directly from UN agencies and to receive goods, vaccines, food, health and medical supplies that they weren't able to receive prior to that from the UN. So really, it just completely changed the response and really improved it dramatically. And it has taken time, but I think we are at a very, very different place now than we were prior to the resolution, and we can't even compare the response now versus before.
Thank you. And Rachel, would you like to add something from the perspective of other NGOs and how was their experience on the ground?
Sure. I think there's two more indirect implications that we also saw. So the first one was the fact that it created greater acceptance within neighboring states to Syria. So Iraq, Jordan, I'd say particularly Turkey, when it came to the nature of cross-border, it allowed for NGOs to register themselves in the way that they did, and that acceptance was definitely bolstered by the resolution. The second implication, I would say, is the fact that the coordination arrangements that Misty mentioned, the whole of Syria architecture, they definitely weren't established by the resolution, but they were facilitated by it. And it allowed the UN to therefore engage, coordinate, and speak for actors that otherwise may have been seen to be acting in violation of international law prior to the resolution having been adopted. So that's been really essential to dialoguing with organized armed groups, to interacting with various local and national authorities that have a stake in what's taking place in Syria, that have a say over how aid may or may not be delivered in different parts of the country. And those are effects that we still very much utilize to this day.
Right. And now if we fast forward to 2020, the year that has been transformational for so many existing structures, including the UN Security Council cross-border regime. So it in a way opened the door and facilitated that humanitarian delivery across the border and cross-line until 2020 in January, when for the first time Security Council voted a new resolution 2504 to remove two of the named crossings from the arrangement. Yarubia, which is crossing on the border with Iraq, and Al-Ramta, which is on the border with Jordan. 6 months later, just a few weeks ago, on 11 July, the original 2014 cross-border mechanism was down to even more. It's down now to only one entry point from Turkey into Syria, and that is Bab al-Hawa. So this outcome has given rise to uncertainties within this complex legal and operational environment to efficiently fund, manage, and deliver cross-border relief operations into Syria. So let us now see how these new arrangements of exclusion of the three named crossings what is the impact as a matter of law? So Professor Bothe, could you explain this to us?
Well, it was nice to hear that the first resolution was an improvement, and that let us gives food for thought what the political maneuver which happened in the Security Council recently really meant. Apparently, for certain powers, the effect of the first Security Council resolution was just too good for the population. And what was intended was to put a little bit more pressure on the suffering population by reducing the improvements which had been brought about by the first resolution. The legal effect is still the same as far as the one crossing, which is mentioned in the recent resolution, is concerned. But one has to recall, and that has been clearly said, that the original resolution nor the recent resolution do not contain the word only. So what was the rule before? Namely, that cross-border operations could lawfully take place without the consent of the Syrian government. This rule still applies. But it applies without the support of the Security Council, which was given by Resolution 2165.
Thank you, Professor. And Emanuela, would you like to add?
The sport crossing, which was mentioned in the new resolution, is more risky, again, as a matter of fact, but not as a matter of law.
Yes, absolutely. Emanuela, would you like to add something to this legal analysis?
Yes, and in a way, Michael and I are both back to the original positions that we were presenting. So let me present what it means. I think we both agree that we're back to the ordinary rules of IHL, and something that I keep on reminding humanitarians is these ordinary rules of IHL require you to negotiate. So let's not forget that. Let's not be lulled into a sense of, I don't need to do anything anymore. It's up to the Security Council. If the Security Council doesn't do it, then I can't do anything. That's wrong as a matter of law and wrong operationally. So it's a matter of negotiation. Now, as a matter of law, Michael has presented the consequences based on the view that the consent of Syria is not required. Let me present the consequences if we were to say the consent of Syria is in fact required. What does that mean? Well, and this is where it gets a bit complicated. Let me first go back to the United Nations. As I said, the position of the United Nations has been that without the consent of Syria, it will not carry out relief operations. So without the consent of Syria, the UN itself is not going to conduct humanitarian relief operations. What we have also seen is that the UN has said we can also no longer fund operations by others that are not authorized by the government or Syria or by the resolution. And something that really struck me in the presentations by Misty and Rachel was the importance of the soft support in terms of coordination and the architecture of coordination and support that the UN is providing. Question mark to what extent the UN is willing to continue doing all of that. That's just a consequence of the UN's reading of whether or not consent is required. What about the actors that are carrying out the relief operations without consent? We've got to draw a distinction here between actors such as states and intergovernmental organizations such as the UN. Entering without consent could be considered a violation of public international law. The position's different for NGOs. A private actor doesn't violate a state's sovereignty if it enters, so they're not exposing themselves to claims that you violated international law, but they could be exposing themselves to proceedings before Syrian domestic courts for having violated Syrian law by entering without authorization.
Thank you. And Professor Bothe, would you like to add something to that, especially to the last point?
Yes, indeed. I think if you look at the humanitarian law picture as a whole, what is the position of NGOs in this. NGOs do something which is required by international humanitarian law, which must be facilitated by the states concerned. So subjecting private persons who do what international humanitarian law requires cannot be considered unlawful by states. And I can only hope that the courts of a country concerned in this, to that extent, if Syrian authorities get hold of the territory under Syrian governmental control. But if they do, the courts, I hope, would respect what international humanitarian law requires. And that means they should respect that there was a duty, which was an international duty, which was fulfilled by these actors.
That's a very important point, Professor. Absolutely. And we've touched upon the legal consequences for United Nations, for private actors such as NGOs. What about donors? What about legal consequences for funding such unauthorized operations?
Well, donors are in a way is formula in passive children undertaken. And if donors do something, help to expedite operations, they are fulfilling a duty of international humanitarian law, which is addressed to whom it may concern, so to say. And this means that the rules which we discussed, which I explained, that it is lawful and humanitarian law that such operations take place if no agreement is, no consent is required, or if consent is arbitrarily withheld. It means that donors are, so to say, on the safe side of international law if they continue to donate.
Emanuela, would you like to add something to that point?
Yes, and I think Michael and I agree. I'm just going to perhaps look at two slightly different aspects on it and reach the same conclusion as Michael.
I don't hear anything.
Okay, can you hear me?
Yes.
I'm going to add a dimension, but reach the same conclusion. So the funding of humanitarian relief operations is not something that's addressed by IHL. The rules.
It appears that there's a question is asked to me, but I don't hear the question.
I'm answering.
No way. So I hope that what I was saying was a kind of comfort, both for the organizations providing relief and for the donors. And I repeat, that is not a matter of Syrian sovereignty. It is just a matter of humanitarian concerns, which are the object of bind.
Thank you, Professor. We got to that point, and I think it's comforting for sure to hear your conclusion on it. And Emanuela would also like to add something to that.
And I agree with the comforting conclusion. I'm just going to look at it from a different angle, which is IHL doesn't address funding per se. The rules that determine the lawfulness of funding of unauthorized operations by NGOs are addressed by the rules of public international law on the responsibility of states and intergovernmental organizations for internationally wrongful acts. And these were codified by the International Law Commission in 2010 and 2011 respectively. And there are two possible bases for concluding that funding would violate international law, and neither applies in the present circumstances. Neither. Michael. The first is if the unauthorized operations could somehow be attributed to the state or intergovernmental organization providing the funding. And the second would be if the provision of that funding could amount to aiding and assisting the commission of an internationally wrongful act. And neither circumstance, neither possibility arises in the present circumstances. If we look at attribution to a state of the acts of a private actor, this is something quite exceptional. It may arise, it's something that's addressed in Article 8 of the ILC Articles on State Responsibilities, that determines that in certain exceptional circumstances, the private action can be attributable to a state if that actor, so in our case, the NGO, acted under the instruction, direction, or control of a state. Now, the threshold for reaching this conclusion, that an NGO is acting under a state's direction of control, is high. It was something that was addressed by the International Court of Justice in the Nicaragua case, with which many of you will be familiar. And here the support that the US was providing to an armed group, even if preponderant or decisive in the financing, organizing, training, supplying, and equipment of this armed group, was nonetheless still insufficient for the acts to be attributable to the US. And in particular, the ICJ also specifically addressed the question of funding, and said that the funding of the activities of a private actor does not render its acts attributable to the state donor. So that possible basis for responsibility does not arise. The second one would be if the donor state could somehow be aiding or assisting the commission of an internationally wrongful act. This is addressed in Article 16 of the ILC Articles on State Responsibility. And this is something that can occur when a state aids or assists another state in the commission of an internationally wrongful act. And immediately we can see it's not applicable in these circumstances because it is an NGO that's committing the unauthorized act, so it's not another state, and moreover, it's not a violation of international law if an NGO enters the territory without authorization. So I agree with Michael on his conclusion. I'm getting there from a different body of law. General public international law also takes us to the same conclusion.
Thank you. Thanks for really that comprehensive overview. I think it's very important for donors to understand this part and to continue funding cross-border operations, even with 2020 changes in the UN Security Council resolution regime. But let us turn back to the situation on the ground. Maybe Rachel, you could give us a brief overview of how this change impacted operations now. What is going on?
So the most substantive impact is something that Emanuela touched on, which is the impact of the UN's internal decision not to fund partners operating in the Northeast as the border crossing of primary use to NGOs. So the major impact in January that was felt when Yarubia was removed was quite substantial. In monetary sum, it was about $40 million in funding that was no longer accessible to NGOs because they were either receiving that through the Syria Cross-Border Humanitarian Fund, which had not too recently offered a new allocation of assistance, and about 30 of those $40 million were dedicated to medical services. So it was a really significant impact right off the bat. Obviously, the allocation of the pooled fund was felt more immediately than any loss in direct bilateral assistance committed by individual UN agencies to their partners. That has continued to be felt by NGOs who had different contract lengths, different program commitments that were made by those due to that decision. So that's really the major impact that was felt on the funding side of things. In addition to that, more recently, the various renewals and the general uncertainty as to which border crossings would be named, how long the resolution would be in effect, through the humanitarian community into a tremendous amount of frenzy. There was decision paralysis, not a lot of ability to plan ahead and to be prepared for what we saw as various scenarios that could have played out each time the United Nations Security Council met to either vote or to renegotiate various drafts of the resolutions that were under consideration. So those were two of the issues. The only other issue I just want to flag now is, of course, with the removal of the northwest border crossing, we're still really assessing what the implications are on ongoing cross-border operations into that part of the country. Initial findings are, of course, that it is introducing a lot of uncertainty when it comes to logistics. So how do we get the same amount of goods in through only one channel instead of two, recognizing that that border crossing point was already rather overstretched. It raises questions about if there's more insecurity or access constraints, how do we continue to serve the same locations and continue to reach the same communities, but with fewer options, essentially. And I'm sure Misty has a lot more to add on that one.
Thank you, Rachel. So Misty, would you like to add something from your operational perspective on these changes on the ground?
Sure, thanks. And I mean, I think that Rachel has done a pretty good job of covering the the impact. Certainly, we have with Yarubia, we lost to see how that has played out and the impact. And as Rachel said, the health and medical sector was one of the most impacted because NGOs across the board, very many of them were relying on the UN. It's very clear that there has been quite an impact from the removal of Yarubia. I think we still will be seeing what will happen with the removal of Bab al-Salam border crossing into the northwest, and just maybe to also complement what Rachel was saying, in addition to the cost estimates are probably going to increase as well, or the cost of delivering to the same area is going to increase. And, we're hearing potentially up to 30% increase for delivering the same aid. We saw in May, 1 million people served with health who can't, be reached that way now, and it will have to go through the other crossing. So we're still waiting to see at the ground and operationally what the impact is going to be. But I think the bigger issue and piecemeal erosion of access that we're seeing, and the politicization of aid, and instead of looking at the needs on the ground and looking at every way that we can be reaching people, instead our access is slow.
Thank you, Misty, so much. So this is really an amazing overview of where we are, and the news are not that good. But we've been focusing a lot through our talk on the legal consequences for carrying out unauthorized cross-border operations by United Nations, by private NGOs, and funding such operations. But I would also like us to address the legal consequences of the other side, of the party that is responsible for providing that humanitarian assistance. And what are the legal consequences for responsible parties that are withholding the consent arbitrarily? Professor Bothe, would you like to maybe address this very, very important subject?
Well, certainly what we have just heard makes clear what happens there. This tactics or strategy of withholding consent, of preventing relief, because that's what it is part of a military and political strategy to use the suffering of the population as a means of warfare, of regaining control over that little part of Syria, which is still in the hand of the so-called rebels. Now, using starvation, because that's what it is, using starvation as a means of warfare is a war crime. A war crime punishable under international law, and under national law, where national law implements the requirements of the Geneva Conventions on Grave Breaches. And this can be prosecuted under the rule of universal jurisdiction. So all those who are personally responsible in one way or the other for implementing, for making these policy decisions, for implementing them, run the risk of being prosecuted as war criminals. And there are states which take the rule of universal jurisdiction, which is in the Geneva Conventions and in customary international law, seriously. So if it works as a travel ban for those persons. That's perhaps not enough, but it's more than nothing.
It is, and thank you, Professor, for that point. Finally, I'm mindful of time, and I would also like to open the floor for questions. But before that, I would like to briefly address the development of this year that has impacted our lives privately, professionally, at all levels, and that's COVID-19 situation. And it has also had an effect, certainly, on the humanitarian crisis inside Syria. So would you, Professor Bothe, explain to us how the situation of COVID-19 would have an effect on everything that we've talked today as a matter of law?
Well, it has a great effect because it adds to the urgency of the relief requirements. If it was urgent before, it's now even more urgent. And to put that into a legal language, even if unauthorized relief operations conducted without consent were unlawful, and you have heard I'm of the opinion they are not, but even if they were, we have a case of necessity, which is a general principle of international law, which precludes the wrongfulness of any act done, which is necessary to safeguard essential interests. And here we have essential humanitarian interests which are in peril. And therefore, this situation of need, so to say, adds to the legitimation of relief operations, providing in particular this medical relief.
Thank you. Emanuela, would you like to add something to that point?
I completely agree with what Professor Bothe said, and what was striking when Misty and Rachel were speaking was how much the medical response has been constrained at all times throughout Syria, and also the impact of the non-renewal of Yarubia on the import into the country by the UN of medical supplies and equipment. Very much just before COVID was about to strike. And like Michael, I agree that we might find ourselves in a situation where necessity is applicable. I just wanted to a word of warning as to precisely how possibility to derogate from human rights instruments. That's something that we've also heard about in COVID times, the entitlement of certain states to suspend the application of certain rights because there is this public emergency threatening the life of the nation. And possibly COVID has been interpreted as that. Necessity operates in a far more specific way. We've got to be aware of that. So it's not as if it's possible to suspend the rules of IHL, of public international law as a whole. Necessity is narrower in scope. It relates to a very specific act that is the only way to safeguard an essential interest against a grave and imminent peril. So the case needs to be made on each occasion. For example, to say, it is absolutely necessity means that I must bring this consignment of medical goods in to this particular part of the country to respond to this particular need. So again, something for us to bear in mind in terms of how it applies, and I think more importantly in terms of the legal debate, to provide reassurance to the range of actors that are involved in shaping the response, be it in terms of direct operation, funding, or negotiations.
Thank you. Misty and Rachel, would you like to add something from the operational perspective briefly, if you have anything to add to COVID-19 situation and humanitarian?
Maybe just to contextualize, in addition to COVID-19 and the subsequent removals of these different named border crossings from the resolution, we're also dealing with, especially in the Northwest, an increasingly complex operating environment where access is constrained by the rejigging of power dynamics, of individuals seeking influence and interfering in humanitarian operations on a regular basis, frustrating the delivery of assistance and the modalities in which it's already being delivered, and that's not going away. So it's really a combination of time, and having to is another headache on top of already what is really unmanageable for many NGOs who are trying to adapt to an ever-changing context. So when it comes to preparedness efforts for COVID-19, scaling up isolation centers, bringing in the necessary medical equipment and supplies. We're talking about having to figure out new logistical processes, repaving of roads, new security assessments and new routes, all of which is going to, I think, affect the ability to scale quickly and the effectiveness of the preparedness efforts that should have happened a couple of months ago and are ever more pressing because the number of cases is indeed rising across the country.
Misty, would you like to add something to that?
Just briefly to complement what Rachel has already said. I mean, I think it has always been complex to deliver aid, and it's increasingly more complex now. And I mean, the COVID pandemic it has been spreading across the country, and now we have 29 confirmed cases in the Northwest. We have 12 confirmed cases in the Northeast, but we're not really doing, the testing is very minimal, and so it's very likely that this, we're just seeing the tip of the iceberg now, and that in the coming weeks and months. And, you know, we're really constrained now, even more constrained than we already were, because we are seeing this shrinking of access and uncertainty. So yeah, it's never good timing in Syria, and it's with the COVID-19 pandemic, it's just really the worst possible time to be losing access.
Right. Thank you so much for this informative debate. I would like now to open floor for questions. We already have a few coming in. So one of the questions asks, to what extent do you think, and I would say maybe Emanuela and Professor Bothe, what do you think an UN General Assembly resolution would maybe be an appropriate way to reinstate cross-border assistance through those crossings that got excluded now?
Well, if I may try, Manu, or do you want to be first? I think you can correct me afterwards. General Assembly resolutions are a political tool, which is important, politically important, not as a matter of law, because the General Assembly does not have the power to impose legal obligations. But that said, I think a General Assembly resolution would be useful because it adds the political pressure and is a political tool to reduce the grip which certain powers have on the poor, suffering population. So my answer is yes.
Emanuela, would you like to add something when it comes to this question?
Yes, I completely agree with Michael as to the law. My concern throughout this Syria crisis has been about the politicization of humanitarian assistance, and it's something that we've seen very much at the time of the subsequent renewals. And those of you who followed the discussions might have seen, will have picked up like me, that there were a lot of suggestions made by members of the Security Councils to pressure others that were left you thinking, really, it's whose interests you have at heart, those of the population in need, or you just want to get what you want in the resolution. So that's my only concern about the involvement of a political body, whether it's actually going to be in any way helpful on this occasion. That's my question I have.
Excellent. And another question that is legal in nature, but I think also maybe Rachel and Misty can contribute. The question is about the responsibility of NGOs when they're engaging with responsible parties in the conflict and the local authorities, and primarily when it comes to the compliance with the core humanitarian principles of independence, impartiality, neutrality, and humanity. So what is also the responsibility of NGOs under international law, but I would also say from ethical perspective, when you are engaging with the parties and how you are showing those principles that you are complying with them? So maybe...
well, if the two ladies still want a moment to think about, may I add something which is also not really legal, but has legal implications. If you negotiate access to people in need, you have to be in contact with persons or authorities which you do not really like, and with reason you do not like them. But if you want to fulfill your task, your function, you have to talk. It's as simple as that. And if these negotiations are conducted in a sensible way, they are not against the humanitarian ideals and functions of the NGOs in question.
Right. Misty, you wanted to add something, and Rachel?
Sure. Yeah, and I mean, I think it's a really important point that has come up, and that it's quite critical that organizations who are working on the ground are aware of humanitarian principles and how they can, you know, abide by them in their day-to-day work when you're coming into these kind of situations, which are, you know, are extremely difficult, and you're dealing with numerous on the part of NGOs to make sure that we are to be able to negotiate these really difficult situations and you know, stay in adherence to humanitarian principles.
Rachel, we want to add something.
Maybe just to add, I think it's an important reminder because it reinforces that even if we do have a Security Council resolution authorizing the work that NGOs are doing, it doesn't solve the problems that arise on a day of independence. I think that's one that we've seen across the board where we're working to be the most difficult at times to uphold, because you have a cohort of very strong actors, some high regulatory entities that really want to determine how aid is delivered, through what modalities, in all parts of the country. This is something we've struggled with. So I think it is an important reminder that just because we have these legal frameworks in place, there's a duty that operational actors have to make sure that in practice, the way that we're going about our work is very much in line with the humanitarian principles. The only other thing I would add is that we haven't spoken very much about the conduct of humanitarian operations in government-controlled Syria, but it is really important that we use discussions about to also remind people that the way in which aid is delivered from and within government-controlled Syria also needs improving, that we need to bolster the capacity of NGOs and UN agencies alike to negotiate with some really tough actors, to establish some clear parameters and principles in which they operate, and to be comfortable if those conditions aren't met, withdrawing, suspending, pursuing other ways of demonstrating that they're not willing to compromise on some of these core values.
Right, that's a very important point. Thanks, Rachel. Another question is addressed specifically to Professor Bothe. It is slightly complex legal question, so I'm going to slowly read it out for everyone. Professor Bothe, you indicated that sovereignty is bound by other obligations under international law. Could you please elaborate on what such obligations are, and when such obligations would trump sovereignty? As an example, would the duty to facilitate rapid and unimpeded humanitarian access be one obligation?
Yes, of course. Sovereignty is a shorthand expression to the sum of powers a state has on its territory, and infringements on the right of sovereignty and territorial integrity are prohibited unless they are authorized by international law. So just emphasizing sovereignty is really starting the questions from the wrong end. The question is there a rule of international law which gives a right, something which has not been mentioned so far, the right of the suffering population to receive relief, regardless of who is the sovereign. and the right of other actors to provide relief. This is international law, and because it's international law, it limits sovereignty. So the real question is not sovereignty. It is, what is the rule of international law? And if there is a rule, you can't argue sovereignty against it.
Thank you. And Emanuela, would you like to add something to this point?
Just to say, I agree with Michael on this. Our point of disagreement was whether or not the rules that we found in Additional Protocol 2 or in Common Article 3, in fact, removed the entitlement of states to how they affected state sovereignty. And essentially it went to a question of whether they were sufficiently clear or not, and that's where the divergence of views rested. I think something on which Michael and I both agree is that consent is required, be it that of the state or the organized armed group. Consent is required, but may not be arbitrarily withheld. And I think that's also something that really didn't come out because we focused on the question of whose consent is required. But I'm sure that we're in agreement that as a minimum, it is the consent of the party in whose territory you want to conduct the operations. And that's something we mustn't forget. Unless, of course, the Security Council has acted and removed that requirement of consent.
Thank you, Emanuela. There is a very important question that just came up, and that is what key messages can NGOs and civil society organizations use when they're advocating and lobbying international donors to continue their funding despite the changes to the UN Security Council? We did talk about circumstances precluding wrongfulness and other legal reasoning why it is safe for donors to continue the funding despite the UN Security Council resolution changes. But Rachel and Misty, from your perspective as advocacy experts, how would you frame, how would you advise or recommend your fellow humanitarian organizations to transcribe that legal language into a good advocacy message?
Sure, I'm happy to start with this one. I think, we're hoping this isn't really an issue. I think the feedback that we got from international donors back in January when Yarovia was removed, there was a bit of trepidation and uncertainty at the onset about whether it was still lawful for them to continue supporting NGOs. I think we've mostly addressed that, but if there are still questions, I think it's worth reinforcing some of the points that, but I think really reinforcing the distinction between what was a decision that was made by the UN in their legal reading of what would not be lawful for them to continue doing, and distinguishing that from supporting NGOs. So those are two different things, and I think that the decision that the UN made certainly sent a certain signal, and we need to kind of separate ourselves from that a bit, because it's really going back about reinforcing the criticality of meeting the needs on the ground, of emphasizing that there are various means through which support can be provided. So, of course, continuing support through the Syria Cross-Border Humanitarian Fund in the Northwest. We want to see that, but also emphasizing that bilateral channels of support very much continue to exist and have not been at all disrupted as a result of the changes to the resolution. I would also say that we found a lot of donors are also opening up new funding opportunities that come with COVID-19. And so it's really about reinforcing the need to be scaling up quickly and to meeting needs related to the pandemic that need solving now.
Great, that's very useful. Thank you. Misty, would you also like to share some of the recommendations? You are one of the leading forces of the advocacy work on cross-border operations also.
I mean, I think Rachel covered it really well. I mean, I think that, you know, I fully agree that I would hope that we're not going to have to argue the case with donors. I think we have a long history over the years of showing the impact of the support that donors are providing for cross-border aid, and that, you know, we are able to continue that. You know, I would hope as well that whatever happens in the future, that UN agencies will also take a, you know, will continue supporting cross-border and not take an overly maximalist interpretation if there are changes. And you know, I think we, as you know, Rachel had said, we were quite caught off guard, I think, in January, and it happened quite suddenly. And we certainly would have liked to have seen some of the support continue that that didn't, in terms of coordination and in terms of the pooled funding and other things like that. So I think, you know, we would be encouraging as much support to continue as possible, and really focusing on through the lens of what the needs are on the ground, and how, you know, although there may have been some changes on the ground, the humanitarian needs are as dire now as they ever have been. And, you know, we are seeing the results of the COVID pandemic slowly, that's coming, but also, you know, the economic meltdown that's been happening in Syria has really taken a big toll as well on people. And prices have increased, and you know, so the humanitarian situation is not improving, even though we are losing access. It's actually decreasing. It's actually getting worse.
Right, and this is really important point to make, and you know, the entire conjunction between legal, political, and economical deteriorating situation that has the entire impact on the civilians inside Syria. I'm mindful of time, and here I would like to invite each of you to share with us just a few final points, or not more than a minute, just for final reflections, or where you would like us to leave this discussion today. Maybe Professor Bothe, you can start.
Well, I think, allow me to approach the question in a historic perspective. The role of international humanitarian law over the last 200 years or so, a little more, has always been to defend humanitarian interests in the face of contradicting state interest, to save the human person in the situation where it was threatened by what was perceived as a state interest at the moment. That has been so over the centuries, and the challenge is, I think, more severe than it was ever before. And therefore, it is very important not to lose the moral lodestar of international humanitarian law, and Syria, I'm afraid, where this is a real danger which must be faced and fought against.
Thank you, Professor. Rachel, would you like to share some?
Sure. Perhaps to pick up on something that Emanuela said, I think we need to remember that we can negotiate access with or without this resolution wherever we are in Syria, and especially recognizing that the way the trajectory of the renewals have been going with the current arrangements. And so it's not too soon for agencies who are looking ahead to the next 12 months under the framework of the current resolution and beginning to prepare for whatever comes next, but also sharpening their negotiation skills to secure access through whatever means possible. I think this actually gives us an opportunity to be looking at new areas for opening up programming where we haven't been before, interacting with stakeholders in new ways, which is a complete absence of cross-border under the Security Council resolution. At the same time, and going back to a point I made earlier, all of this needs to be accompanied with the ongoing dialogue that many Damascus-based NGOs and UN agencies have to expand their reach. And it's not perfect for Damascus-based agencies to match the scale, the quality, the sustainability of cross-border operations, and that's not going to be solved overnight, if ever. But the important thing to remember is that this is an area that will need development in the months to come. The pressure that human rights organizations place, that donors place on increasing the quality of the Damascus-based response. Sometimes it can feel like a lot, but it's really important to raising the bar and to making sure that aid is delivered in line with humanitarian principles. And so that's really where we should be focusing our efforts into the coming period.
Thank you, Rachel. Emanuela, would you like to share with us your reflections?
Yes, at three different levels. I think that specifically in relation to Syria, this involvement of the Security Council was extremely valuable and important. And as we've been hearing, it was fundamental that all modes of delivery, cross-border, cross-line, and within areas within the control of the government of Syria, continue and enhance. So it was something extremely positive. As you heard me, I was concerned by the politicization of something that should be an exclusively humanitarian endeavor and negotiation. It was problematic in Syria. We are seeing it elsewhere. What about this Security Council involvement as a precedent? I'm a bit concerned at two levels. Why? It might not happen ever again that the stars align and that Security Council's willing to do this. But I worry that we might find ourselves in a situation where a recalcitrant state is going to say, unless and until the Security Council adopts a binding resolution telling me to do something, I have no obligations. This is obviously not the case, and we've got to guard against that. As equally, we've got to guard against our own laziness as humanitarians. We have got to negotiate. It is incumbent upon us to carry out this. We should not sit and wait for the Security Council to adopt a resolution. That's not how the system works. And then finally, a reflection on what this has meant in terms of IHL. And I think positively isn't the right word, but it has led us to look more closely at the rules regulating humanitarian relief operations. And this is something that is positive and long overdue. It was a part of IHL that really hadn't received much consideration. And there was no reason for this because a greater number of civilians die and suffer as a result of humanitarian crises prompted and exacerbated rather than from the conduct of hostilities. So I think this is possible. And in terms of the big battlegrounds going forwards in terms of IHL, I actually think that both in terms of the actual provision of humanitarian assistance, but also interplay between IHL and counterterrorism, which is one of the big areas of tensions in IHL today. We are witnessing it being played out in the context of these rules. And we haven't really discussed it in relation to Syria, but it is a big additional challenge as well. So it's good we've been mobilized, but the battles are far from being won. They're being fought now.
Yeah, thank you, Emanuela. That's a powerful message. Misty, what would you like to add and conclude this panel?
Well, it's a tough three panelists to follow, but I think very briefly, I would just say I mean, I think that the cross-border resolution was groundbreaking. It was the first time that the Security Council unanimously agreed to Syrian civilians at the forefront. It may have been the only time, in fact, and it has vastly improved the humanitarian response. I think its provisions are still critical, and we need to continue to advocate for that access as long as we can, and for it to continue as long as possible. At the same time, I think that, you know, cross-border is not the beginning and end of humanitarian access in Syria, and the situation is changing, and we do need to be looking at all of the different ways of access. I mean, I think the cross-border, the fact that we can do cross-border has shown that there are other ways of providing access. You know, I think we need to be looking at all of the options, but also, you know, coming back to as well the responsibility and accountability that's needed for a principled and effective cross-line response as well. And I think with so much focus on cross-border, some of those other modalities sometimes do not get the same level of focus. And we really, you know, need to make sure that the parties that have obligations to facilitate and allow humanitarian access are in fact complying with those obligations that they have, and that, you know, we can see a more holistic response, hopefully, going forward.
Thank you all for so much for this fascinating talk today. And really what I'm taking with me and what is impulsing across the entire discussion is that human impulse of compassion to help the other, and finding all the ways through those legal and operational obstacles to really reach out to every person who needs to stay in life and in dignity every day while affected by the armed conflict. Thank you also, all of you who found the time to join us today for this discussion. We have mindfully recorded it for everyone to enjoy it later. If you have any additional questions or would like to discuss further, please feel free to reach out our help desk of the Lebanon Resource Desk for International Humanitarian Law. Thank you, and I wish you a great day. All the best.
Thank you.
Thank you.
Bye.
Bye-bye.